My name is Tom Langford. I'm an immigration attorney, and this video comes to you from my immigration law office in Benicia, California. Today, I want to talk to you about the provisional waiver. The new provisional waiver is a procedure that's been created by the United States Citizenship and Immigration Services to apply for a waiver of unlawful presence. We've been receiving a lot of questions regarding this new program, and I want to take this time to answer the 10 most common questions. The first question we get is, who needs a provisional waiver? Well, if you are applying for an immigrant visa, that is a green card, and you have been illegally in the United States for more than 6 months, you probably need to apply for a waiver before you can get your green card. Now, you may have entered the United States with a visa and overstayed your visa. You may have entered the United States without a passport or without a visa. You may have crossed the border without inspection. In all these cases, if you remained in the United States after you were 18 years of age for more than 6 months, then you will have accumulated unlawful status and will probably need a waiver. The second question we get is, will I be able to stay in the United States while my waiver application is being processed? Yes, this new procedure allows you to remain in the United States, file your application waiver inside the United States, and remain here with your family while you wait for the Immigration Service to make a decision on the waiver application. The third question we get is, when can I apply for a provisional waiver? A visa petition must have been filed with the Immigration Service and approved. The approved visa petition must then have been registered with the National Visa Center before you can apply for a provisional waiver. If you have already been scheduled for an interview at the consulate on your immigrant visa, you are not going to be eligible to submit the application for the new provisional waiver. The fourth question we get is, who can apply for a provisional waiver? You must be physically present in the United States. You must be at least 17 years old. The immigrant visa must have been approved, and it must be registered with the National Visa Center. And lastly, you must be the immediate relative of a United States citizen. Your relative must either be a parent, a spouse, or a child who is over 21 years of age. The fifth question we get is, what do I need to prove in the waiver? You need to prove that if you were refused a visa based on your unlawful presence in the United States, it would be an extreme hardship on your citizen parent or spouse. So how do you prove this extreme hardship? Well, extreme hardship is a very high standard in the law. You have to prove financial, social, emotional, mental, or physical hardship to your relative in order to get the waiver approved. This will require evidence from family, friends, representatives from the community, professionals, and healthcare providers. The seventh question we get is, what happens if the provisional waiver is denied? If the waiver application is denied, there is no appeal. You could refile the waiver application, but you would have to repay the filing fees, and you would have to submit new or additional evidence in support of your request. The eighth question we get is, if I file for a waiver, can I get interim benefits? If you file for the waiver, it does not change your status inside the United States at all. You cannot apply for work authorization. You cannot apply for a travel document. It does not protect you from deportation or removal from the United States. And it doesn't stop you from accumulating more unlawful presence. The ninth question is, what does the waiver do? If immigration approves the waiver, it allows you to leave the country to attend your immigrant visa interview with the knowledge that your visa will not be denied because of your unlawful presence in the United States. The 10th question is, what do I do if my provisional waiver is finally approved? Well, if the provisional waiver is approved, you're going to need to depart the United States and attend your scheduled immigrant visa appointment at a U.S. consulate abroad. For Mexican nationals, this means that you would travel to Ciudad Juarez to attend an interview at the Consulate General in Ciudad Juarez. Do I need an attorney to file for a waiver? It will take a lot of effort and money to prepare a waiver application. Before you make this commitment, I highly recommend that you have a full consultation with a licensed immigration attorney to review your immigration history to see if this is the right solution for you and your family. In summary then, the stateside provisional waiver will allow applicants for immigrant visas to remain in the United States until a final decision is met on their application for the waiver of their unlawful presence. If you have more questions, please call my office at 707-747-5133, or you can email me at vtlangford, Langford, @earthlink.net. Or if you want more information on this program, please visit my website at thomaslangfordlaw.com. Thank you.